Jessica Saxton, followed by Tanawa Downing.
Good evening. My name is Jessica Saxton. I'm a civil rights advocate and litigator from Washington, D.C. I am here to provide notice to the council this evening. This is in accordance with USCS Rules of Civil Procedure, as well as Rule 17 and Rule 20 of the United States Supreme Court. The Constitution for the United States is the overarching requirement that every state must follow. I don't think that any one of you here would disagree with that. States are not able to enact their own alternative legislation and substitute that for the guarantees of the Constitution. That would mean that your state laws are more powerful than the Constitution, and that is simply unlawful. So Clause 1 of Amendment 5, like the previous lady was just speaking about, says that no person should be held to answer for a capital or otherwise infamous crime unless on presentment or indictment by a grand jury. That also includes our citizens. Unfortunately, your state has enacted a law in its inferior constitution that permits your public officials, your law enforcement officers, your judges, to charge by way of information as opposed to indictment, and that is simply unlawful. An emolument violation is when you pay a public official to commit a crime. There are two areas within our Constitution that reinforces this. The first is Article 1, Section 10, and that's where it states that no state shall create any law that shall impair the obligation of a contract. Your police officers, your prosecutors, your judges, they're all under a contract. You are under a contract. That's a contract to perform based on the oath or affirmation that you took to support and defend the Constitution of the United States of America. The second area that reinforces is the issue of an emolument violation and paying public officials to commit a crime is the 14th Amendment, and that's where it states that no state shall create or enforce any law that shall abridge the privileges or immunities of United States citizens. Privileges and immunities of the United States citizens are at a bare minimum those that are enumerated within the Bill of Rights and the First Amendment. So I am here to provide notice and let you know that you cannot continue to pay public officials to commit crimes against the citizens. It is a crime, it is an emolument violation, it is unlawful, and it is illegal. I do have a notice that I would like to put on the record tonight explaining more about this, and I encourage you to do the right thing. Thank you.
Tanawa Downing, followed by Janice Herrera.
I'm sorry, hold on one second. If you can go ahead and give that to the clerk right there, that would be great, Ms. Saxton. Thank you.
Good evening. So my name is Tanawa Downing. I'm a civil rights litigator that Ms. Saxton was just leading into. I'm about to argue this case in the United States Supreme Court on behalf of more than 700,000 people that are currently in prison here in America illegally and unconstitutionally because the states have failed to follow the very basic procedures process codified in the Constitution for the adjudication of a crime. I want to provide a little bit of clarification, all of you, so you can understand what was just said and what we're actually asking from all of you. I have approximately 12,000 criminal affidavits on behalf of victims that have been charged by way of information as opposed to indictment from right here within the state of New Mexico. Many are from within this county and the city. These affidavits, they identify two particular crimes, all right? The first is Title 18, subsection 242, which is deprivation of rights under color of law. The second is Title 18 U.S.C. subsection 241, which is conspiracy to deprive of rights. So law is a criminal conspiracy with regard to public officials, all of you, that states that any person who, having knowledge of any of the wrongs conspired to be done and who have the power to prevent or aid in the prevention of the commission of the same neglects or refuses to do so may be held as defendants in the action. So upon having been provided with this notice, letting you know that your agents, law enforcement, whom you all pay, are acting unconstitutionally by relying upon an inferior state statute to abridge their obligations codified in the Constitution of the United States of America, I'd ask you guys, please, let's work together to fix this problem. Because the alternative is that I will have to convert these criminal affidavits into criminal complaints, and I don't want to do that. That's not the path that I want to go down. All right? Now, I know that you guys are going to go and you're going to ask the attorney as soon as we're done whether or not what I'm saying is true, and that attorney is going to point you to a case from 1884 called Hurtado versus California. And before you choose to rely upon that as foundation, I must remind you that the Constitution of the United States of America is the foundation, not a judge-made ruling. The Supreme Court of the United States has no constituted authority to be able to alter, amend, or destroy any of the provisions or guarantees of the Constitution, because that must be done by an authentic act of people in accordance with the special amending procedure of Article 5. Furthermore, judges cannot legislate. We know that because Clause 1, Article 1 says all legislative power is vested in Congress of the United States. So I pray that you guys are going to make the right decision here. I know it's a tough one. You guys are going to have to decide as soon as we're done whether you're going to go and you're going to follow a judge-made ruling the lowest form of law or the object to which your fidelity is bound, the Constitution of the United States of America. But just to leave you with this, I want to say that the United States Circuit Court has identified that an erroneous view of the law is an automatic abuse of discretion. An erroneous view of the law would be in your legal contemplation, the lowest form of law, a judge-made ruling, is superior to the Constitution of the United States of America. That would be an obvious erroneous view of the law. Thank you guys so much. God bless, and have a great rest of your night.
Oh, he is a little faith, don't doubt